in Ukraine, Crimea. In many of these circumstances, the settlement project is accompanied by other widespread human rights violations, and those have often occasioned comment by the international community. But there has never been criticism of the settlement projects in these cases in terms of Article 49.6. So, if in none of these situations settlement activity is criticised as illegal, and I indicated it's not the case that the activity has escaped international attention, in many of these cases there has been other criticism. Crucially, the failure to raise legal objections where it's consistent and general across all of these examples and extends to international organizations and groups like the UN Human Rights Council, the International Committee of the Red Cross, and humanitarian NGOs like Human Rights Watch, whose work it is to systematically point out violations of these norms. The lack of an international response here has the effect of legitimizing a policy of government-orchestrated settlement projects. And this is crucially because the development of international law, public international law, through custom is rooted in the practice of states, because it's their practice over time that results in that binding customary international law that I discussed right at the beginning. When we consider that the only example in international law where the issue of settlements has been criticised as illegal is with regard to Israel, I think we have to consider whether the motivation behind that criticism is in fact political rather than legal. Now, finally, I promised that I'd come on to this example, this case study of the recent proposals which have been shelved of the Israeli government contemplating the application of civilian law to areas of the West Bank, parts of Area C in the West Bank. And it brings me in particular to the use of terminology, because the term annexation to describe Israel's proposed application of civilian law is wholly inappropriate, not just because Israel is the underlying sovereign, as I've previously indicated when we're looking at the status of the territory, but also because it's a misrepresentation of what is being proposed. So I'll give you the definition of annexation from the Oxford Encyclopedia of Public International Law. Annexation means the forcible acquisition of territory by one state at the expense of another state. So annexation is about taking for yourself territory belonging to another state. It's what Russia did in Crimea in 2014. It's what Germany did in Austria in 1938. It's what Jordan tried to do in the West Bank between 1948 and 1967. Now, opponents of Israel who use the term annexation make a series of false assumptions. They assume that Israel lacks a claim of sovereignty to the area. They assume that another state actually holds sovereign title to the territory. And they assume that when Israel applies its laws, it will be taking some other state's territory. Now, it's unfortunate that the terminology of annexation is being wrongly deployed here. And it really is an example of where the rhetoric of international law conflicts with the reality of international law, where a rule is made up in distortion of international law against Israel. And that is why you don't see such rules being applied anywhere else. The administrative regime that Israel established in 1967 in the West Bank was intended to be temporary because Israel recovered that territory from Jordan, but it was anticipated, it was hoped by Israel that a negotiated peace agreement at the time with Jordan would swiftly be achieved. And with that, there would be anticipated an element of change to sovereignty, changed the borders as part of a negotiated settlement. That is why Israel applied a temporary framework 53 years ago. 53 years later, it is entirely unreasonable to expect Israel to maintain a situation of limbo, a situation where Knesset legislation does not apply to these areas properly, where there is therefore a devastatingly confusing patchwork of legal administration. You have leftover Ottoman law, Jordanian law, British mandate law, and often utter confusion at how these regulate 21st century issues, where there is a total absence of environmental legislation and the sorts of provisions which benefit the rest of the country, where civilian law is applied in full. So, the proposal of applying Israeli civilian law to these areas really brings with it, would have brought with it, benefits to the local population, in terms of the consistency of the application of law, including Arab inhabitants, because, and it's also not been the case, I know we're straying slightly from the legal aspects of it, but I think it's important to note that it wasn't the case that ordinary Palestinian Arabs who might have been impacted by these proposals necessarily opposed them, because they stood to gain substantially in terms of access to healthcare, access to the welfare system, access to social security benefits, the right to vote in municipal elections, and other rights that attach to residency. So the rights that even non-citizens of Israel, but residents in East Jerusalem benefit from, including the possibility of acquiring citizenship and therefore all of the rights and benefits that attach to being a citizen of the only democracy in the Middle East. The practical implications of the proposals were also terribly misrepresented. There was this idea that it would be a prejudice to what a final settlement would look like. Of course, any proposals around a two-state solution have envisaged sovereign Israeli territory being transferred via land swaps. Most recently, the Trump plan envisaged significant parts of the Negev being transferred in that fashion. So in that sense, it did not affect the situation at all. Israel was still able to negotiate over territory to which its law applies, and it has done so in the past. Now, there is a significant caveat with respect to everything that I have covered with respect to the status of the territory. And you will have seen that what I've done is go to the starting point, at the birth of the State of Israel, to determine what international law says about the territory at that point. And that's crucially because that's the way that international law is applied in these situations. But that is in no way to prejudge what a peace solution, a peace settlement would look like between Israel and its neighbours. It's not to say that the West Bank in its entirety must remain Israeli sovereign territory. Indeed, there is also a strong argument to say that arrangements and agreements that Israel, the State of Israel, has entered into, notably with the Palestinian Authority through the Oslo peace process, which divided the territory. And at this point, it might be helpful if I briefly switch to another map so that people have an idea of what it is when what it is people are talking about when they refer to areas A, B, and C. I was pausing just to get rid of an echo, which seems to have gone. But you can see on this map the division between the areas of Palestinian entire control, which have the big population centers, the big Palestinian population centers in them in yellow. And in terms of Area C, which is parts of Area C with respect to the proposals of the Israeli government concerning application of civilian law, as I've been discussing, that is in this slightly lighter blue coloured area. So the Oslo Accords are just an example of the sort of international agreement which can change, arguably, the status of the territory. But when we're looking at the allegations that are made with respect to Israel's illegal conduct, alleged illegal conduct, the crucial thing is to go to the starting point and work out what the original status of the territory is. And it's on that basis that I believe we can successfully begin to dispel those myths. This has been a whistle-stop tour through some pretty complex areas of international law and political history, but I hope it starts to paint the picture of how terribly international law is misrepresented in relation